Hi guys, it's David Campanile here, owner of Campanile Law. I'm here to discuss with you today one of the things you can't do in your will is disinherit a spouse. As always, if you want to chat estate planning with me, go ahead and contact me at njestateattorney.com. So this is kind of interesting. I had a client contact me about a week ago or so, and she goes, David, my husband passed away. We were married for close to 40 years, and I'm not in his will. What is going on? Just to bring to your attention, I am not 40 years old. I did not draft this will, so this was kind of a new thing for me. And I go, let me see it. So I look in the will, I read through everything. She's not mentioned. And she's going, David, I supported him for so long. I supported him most of our marriage. What can I do? Like, aren't I entitled to something? Absolutely. The answer to that question is yes, you are entitled to something. And what the state of New Jersey has done, basically, is brought together this part of the rule, and it's called the elective share, or if you want to be more stern about it, it's called the forced share. So when you cannot disinherit a spouse in a will, and because there is this idea that marriage is a partnership and you can't basically screw your partner. So what happens is in this case is you take everything that was that individual's, even though there's beneficiaries that need to be paid out in the will, and basically you take the entire estate, you accumulate all the assets, and this is what would be called an augmented estate, but that's just fancy lingo. That's stuff you don't have to worry about. You take the estate and you divide it by a third. You take the value, divide it by a third. That is what the spouse gets. The disinherited spouse would receive 1/3 of the total estate, and then all the payouts would come. So, in essence, you can't disinherit a spouse in a will. There are ways through trusts, and there are marital trusts. There are all these other things that people can do that I'm not getting into. I'm just getting into the basic of disinheriting a spouse. And you see this a lot of times with people who didn't do their spouses who didn't do their wills together, or another spouse who kind of went to an attorney without telling the other one and kind of did things shady and on the backside, and didn't want their spouse to know because, well, I'm dead now, so I don't care how mad you are at me. But in reality, you cannot disinherit a spouse. You have, under the law, you have to give 1/3 of your total augmented estate would go to that spouse, and then your beneficiaries would be paid out. So it's kind of like one of those little caveats, but I was really happy I got to help her out. But I thought this was something that I should bring to your attention, as it's helpful for a lot of people. Again, my name's David Campanile. I'm the owner of Campanile Law here in the great state of New Jersey. We handle estate planning and probate. As always, if you want to speak to me a little bit further about estate planning, any questions you may have, you can contact me at njestateattorney.com. Have a great day, guys.